Good evening. Captain Retired Matt Edwards here with the next Facebook Live Observation Post Weekly Report. Although this week I'm probably going to do two because I'm doing this one because I wasn't feeling well last week. So I figured I'd do one just in case, as I keep telling people, you can't be aware of what's going to happen in the future, mortality and all that stuff. So here I am. I'll probably do two. When I first started doing these, I was doing one a night, one a day. Now, I was feeling off. I don't know why. I threw up once there last Monday, and ever since then I could hardly eat, so I was feeling really weak. So here I am, still alive, sort of, on the 10th of July, 2023. What I'll do is I'll go through four of the points that I have in my numbered list, and I'll also discuss a 36-minute call I had with the Canadian Forces Ombudsman today about what I think is a very important issue. Point number 292 in my numbered list on my observation post files group. I have made up a numbered list of all the things that I think about. Some of them might be duplicated, some of them probably aren't. The RCMP, the Royal Canadian Mounted Police Actuarial Reports in 1996 and 1966 and 1974 with the 10% and 25% Canada Pension Plan Disability Approval rates as stated. Review that point. Now, that ties in sort of with the topic I'm going to talk about later, about estimation of Canada Pension Plan Disability. But what I really want to say, and it's kind of the same thing I've been talking about in the past, is that they designed the Canada Pension Plan at the beginning to give you both your retirement pension, your registered pension plan, plus your Canada Pension Plan, because pensions are property. Now, somebody came up with the idea to make the Canada Pension Plan Disability so tough to get that you wouldn't get the Canada Pension Plan Disability even if you qualify for a disablement RCMP pension or Canadian Forces pension or public service pension. Now that violates the spirit and intent of these acts because they were supposed to give you both according to the minister when you become disabled. Now, because I've talked about that one so much, I'll carry right on to the next point. Number 293, and this relates to the point I'm going to talk about after these 4 points as well. Irrevocable consent. Now, that's the form that Service Canada gets us to sign when we're going to give our retroactive Canada Pension Plan Disability, if we get approved, to the insurance company that makes us sign it. Is it void when the underwriter did not state its role? Now, I'm going to get into that later, but briefly, they state that they are the insurer on this form, but they're not in many cases. Sometimes they might be, but many times it's the employer that is the underwriter of the policy. Now, if you lie on an official form that's meant to divert some of your property from you to an insurance company, I think it's incumbent upon them not to lie on the form. I don't think anybody would fault my reasoning. Number 294, active listening, not lip service. Now, many of the times when I've talked to my Member of Parliament staff or other people, they seem to give me lip service. They're not actively listening to what I'm saying. I don't know why, if it's just natural for people to discount, the logic and reasoning and the evidence of a disabled reserve force veteran like myself. But I always back up things. I don't just say what is my opinion. If I say, for example, that CPPD long-term disability is a non-indemnity and contributory insurance, and I know that because, in the Great West, in the Salts, British Columbia Court of Appeal case, a year before the Dennis Manouche case, I know that the Great West Life policy that the RCMP has, which is a copy of the CPPD policy, that was said to be a non-indemnity and contributory insurance. Now, it goes without reason that the CPPD policy also has to be a non-indemnity. Now, non-indemnity means it doesn't compensate for anything. Now, if it doesn't compensate for anything at all, it doesn't compensate for lost income either. That's logic. If it was an indemnity policy, it might compensate for lost income, but because it's non-indemnity, it's a moot point. Number 295, and I'm rushing this because I don't want to be at this. Why should I have to keep flapping my gums about all the stuff that the government's doing wrong? I should be able to enjoy what's left of my life. But here I am. Number 295, how does Canada compensate for exceptional incapacity allowance issues such as pain and suffering now? Now what I'm getting at is that the government has changed the name of under the new Veterans Charter Veterans Wellbeing Act, they changed the name of what used to be called the Permanent Impairment Allowance, which by law was not allowed to be paid at the same time as the Exceptional Incapacity Allowance, so you can see that the government meant that these two payments were to be the same. So the Exceptional Incapacity Allowance, according to a 1966 Woods Committee report and a 1970 Hansard that I found, they said that one of the things that it compensated for was the pain and discomfort. Now, discomfort is suffering. So the pain and suffering payment under the Pension Act was the Exceptional Incapacity Allowance. Now, under the Veterans Wellbeing Act, you could probably make a case that the Permanent Impairment Allowance, because it was not allowed to be paid at the same time as the Exceptional Incapacity Allowance, well, it must have been meant for pain and suffering. But the government stated that the Permanent Impairment Allowance wasn't for that. They said it was for lost career opportunities. Now later, they changed the name to the Career Impact Allowance from the Permanent Impairment Allowance, and later they changed it to Additional Pain and Suffering Compensation. They said that the disability award was called Pain and Suffering Compensation, and they gave the extra payment that used to be the Permanent Impairment Allowance, they now call, well, it's been a while since I did some of this stuff, so I'm actually starting to doubt myself if I have those things straight, because they changed the damn thing so much. One of the things that the insurance industry does is to try to create confusion. They try to delay and deny, confuse and refuse. Now, because I want to make this short, I'm going to talk about the 36-minute call that I had with a Canadian Forces Ombudsman person, and the reason I called them was that this thing about estimation of Canada Pension Plan, which I've already talked about sort of with the Irrevocable Consent Form, that's one of the things that is involved with the estimation process, and the fact that the RCMP actuarial report stated that there was only a 10 and 25% chance of approval. Well, here's the background. Get a sip of my drink here because I'm a little thirsty. The insurances across Canada, including employers and insurance companies, when they insure themselves, when they underwrite a policy themselves, they want to reduce their costs. They want to offload their costs. So what they've done is, according to Michael J. Prince, after they increased the flat rate of the Canada Pension Plan disability by 300% roughly in 1987, other people noticed how big the payment was. Before that, they left the Canada Pension Plan largely alone. So if you're on long-term disability, they left you alone. They didn't ask you to get the Canada Pension Plan disability. They didn't claw back the Canada Pension Plan disability. They simply left it alone, which is what they're supposed to do. Now, when they saw the government increase the payment so much, they got greedy. Now, this is not my opinion. It's coming from the opinion of an expert, Michael J. Prince, in a book he wrote that I found on Google Books. Now, so the process these days, they don't want to leave it up to you to apply, is that they force you to apply by estimating the Canada Pension Plan disability, and they say to you words to the effect, I'm paraphrasing of course, they say, you know, we think that you can qualify for the Canada Pension Plan disability. So therefore, we're sending you the application forms, including the irrevocable consent and this and that. And after you fill it out and send it in, then we won't reduce your payment. But, you know, oftentimes, now this is the reason I'm making this video partly, is that the Service Income Support Insurance Plan, Policy 901-102, a couple of years ago, I was trying to help a veteran. Her name is Ashley Woodford. And I just realized when I was looking at the letter today that she sent a copy of she covered up some of her, personal details. When she got approved past 24 months, that was the point that they decided to estimate her Canada Pension Plan disability. And that's insane. Now, earlier, last week or the week before, I was talking to a veteran who was out since 2014. So he was out since 2014, and they said, you should get the Canada Pension Plan so we can save money. Now, he couldn't get it legally. In Ashley's case, she probably could get it legally, but it seems to me that they were jumping the gun because they did it right at the 24-month mark. So, this is crazy. They shouldn't be asking, the government of Canada shouldn't be asking a disabled veteran to apply for the Canada Pension Plan disability to get that money for their benefit. It isn't for the benefit of the disabled veteran. It is for the benefit of either Manulife, the Canadian Forces Pension, Veterans Affairs Canada, or all of the above. So, with that in mind, because I've been working on this for years, one of the things that I have to look into is the email that I started to send out. I was going to send it out to every member of Parliament. But I didn't have an email program or a way to copy and paste their names, and I got tired of it after 20 or 30 or 40 or 50 emails. Now, in that email, which I have to try to find, I'm pretty sure I posted it, I said that it was a shame, a dreadful shame, that the government of Canada would take a veteran who was disabled in service and then force that veteran against their will to get a Canada Pension Plan disability to save the government that they served and became disabled under money. You can't tell me that I'm wrong. It must be a breach of the Charter, because we ought to have self-determination. We ought to be able to decide what we want to do with our life. However, this is a standard industry practice. They do it across the board, and they estimate it at the maximum, not what you can get because they know your employment statistics. It's not because, okay, Captain Matt Edward retired. You had 21 years paying into the Canada Pension Plan, and therefore here's an estimate of how much Canada Pension Plan disability you would receive, because the flat rate is always the same amount for everybody. And based on your earnings that you make contributions, you get 75% of that, and here's the amount we're going to estimate. No, they didn't do that in my case. They did it the same thing with the veteran named Dion that I was talking about. They said, the maximum is this much, and here's how much we're going to reduce your SISIP by. In my case, it was Sun Life and SISIP. So in both cases, they estimate you whether or not you actually get it. So that's crossing the bridge before they get to it, isn't it? You have to get to the bridge before you cross it. So anyway, there's only a 35 or 40% chance of you getting it, because the strict definition on the Canada Pension Plan disability, there's only a 35 to 40% chance of getting it. Now, that's increased from the RCMP's actuarial report, but it isn't much higher. So it's not like they're asking you to get something that you know you're going to get for sure. They're acting as if, and I saw this in a 2003 Canada Pension Plan disability study put out in Canada in 2003 called Talking to Canadians. They're acting as if we have an automatic right to the Canada Pension Plan disability, and believe it or not, I agree. We should have the automatic right to the Canada Pension Plan disability if we become disabled. It shouldn't be conditional. Now, with all that being said, I called up the Canadian Forces Ombudsman. I don't know why I did it, because I didn't expect very much. I've had a very bad history with those people. One of the last times I called to them, they hung up on me and said, after the initial staffer talked to me, then I heard voices in the background. Somebody talked to him, and they said, well, she said, I've been told that we are not to engage with you. And then they hung up on me. Now, that's not a very good use of the public's taxpayers' money. You can't simply say that you're not going to deal with someone when they bring you bad news, because they knew me. So This time I called up, I don't know why, but I did. So I talked to this fellow, a brand new guy. I asked how long he'd been working there. He said a year. Well, I said, I got two things I want to talk to you about. The first one is the estimation of Canada Pension Plan Disability by the Service Income Support Insurance Plan. Now, that's a Canadian Forces program. It's long-term disability program. And it takes former, I tried to couch the words in terms so that they wouldn't say, that's not our responsibility. I said they take a former Canadian Armed Forces member who bought insurance, and then after they get approved on medical release, they then make the person apply for Canada Pension Plan Disability, and if they get it or don't get it, they usually estimate the amount, and they take it off that insurance, and they save the government money by taking the money into account. Now, I said that's totally unreasonable because you're forcing the person to do it, and then I said there's a double dip clawback problem. If you got the Canadian Forces pension, I said to him, then the Service Income Support Insurance Plan takes that money into account, and Veterans Affairs Canada takes that money into account. And I said that's why I call that the double dip clawback. And I said if they make a person apply for the Canada Pension Plan Disability like they're doing, then they bring up a more complicated system where the Canada Pension Plan Disability will first be taken off the Canadian Forces pension if a person gets it, then it'll be taken off the Service Income Support Insurance Plan, and then it will be deducted dollar for dollar from the income replacement benefit. So that's why I call this the triple dip clawback. So I said, have you ever heard of the program arrangement between the Department of Veterans Affairs, Sysup Financial Services, and Veterans Affairs Canada? He said, well, I said, you probably haven't because you've only been working there a year. Well, according to the program arrangement, the Service Income Support Insurance Plan under Section 3.2.1 states that they will pay income replacement benefits as the first provider in the event of a medical release. I said, in common sense terms, that means that Veterans Affairs Canada won't be able to claw it back, right? And he agreed, because it's common sense. But they both take it into account, and I said to him, I mean, as far as I'm concerned, you guys are jointly and severally liable. You entered into an agreement, the program arrangement. You agreed that the Army's long-term disability payments would be the first payer, and when they were both at 75%, that meant that the Veterans Affairs Canada had no payment. But when they changed the rate of the long-term of the income replacement benefit in October 2016, that meant both departments had to make a payment, and therefore, I mean, it means that, it's even more complicated. But the fact of the matter is, if one department takes into account, the other one can't. You ought to realize that. That's double dipping. Now, I said it's even worse, because when Manulife sets up the veteran by sending in the irrevocable consent form and the application for the Canada Pension Plan, one of the biggest problems is that these people aren't always legally available to get. They can't get the Canada Pension Plan legally. I said, Dion, he was serving in the military. He got out in 2014. Now, he had until 2016 to get the Canada Pension Plan Disability legally because of the minimum qualification period required in law. I said, if the person applies because they get forced into it by the insurance company, then they're actually probably committing a crime. I said, Canada Pension Plan Act Section 90 says that you're not supposed to, it's an offense to obtain Canada Pension Plan Disability under false pretenses. Now, if you can't get it legally because you don't have the qualifications, then you ought not to apply. But these people estimate to make you apply. So even if you don't apply, they take it into account as if you got approved. So you have no choice but to apply. So when you apply, you then have a 35 to 40% chance of getting it. Now, I said, if you do get approved, I said the irrevocable consent form raises its ugly head. Because if you sign the irrevocable consent form, then when you get approved, Service Canada will send the money directly to Manulife and not the veteran. Now, I said, there's a problem with that or two. I said, first of all, if you get a Canadian Forces Superannuation Act pension, the money went to Manulife, so you didn't get to receive and enjoy it. But you get a bill from the Canadian Forces pension saying that you received the money and you owe money under the bridging provision of the Act. Now I said, isn't it common sense? Don't you understand that if you don't receive the money that they said is the basis of the debt, then you can't owe the debt? And he said, yes, he understood it, maybe because I was stressing it so much when I was going so slow. And I said, then even worse, the Service Canada sends you a T4AP tax information slip. Now the money went to Manulife, don't forget. But you get to pay the taxes on money you didn't get to receive and enjoy. I said, I used to be a tax collector because I was a reservist. I served in CRA as a tax collector in the daytime, and in the evenings and weekends I served in the military. I said, you have to receive money in order for it to be taxed. So one of these days the government's going to had to pay a whole bunch of compensation to people for screwing us over like this. It isn't right. I said, listen, you guys did a report back in 2003. It was called Unfair Deductions, and it led to the class action by Dennis Manouche for the Pension Act clawback under the Pension Act. I'd like to see you guys do a joint report investigation with the Office of the Veterans Ombudsman due to the complicated interaction of these alleged benefits, and to then look at how come this happens, why does it happen, who benefits, because Veterans Affairs doesn't make you apply for the Canada Pension Plan, but they do directly benefit. And the Canadian Forces Pension don't make us apply, but they directly benefit because they use the bridging after you get approved. So I don't know if to look into it, but I said, listen, while I'm at it, I said the second point I wanted to discuss with you is the 2003 report I was just talking to you about. On page 17, paragraph 73, talked about the condition of benefits agreement, which is directly tied to what I was talking to you about before. It says that if you get approved for the Canada Pension Plan, public service pension, blah, blah, fucking blah, then you agreed to pay back manufacturer's life. Or at the time, it was maritime life in the example I had. I said, you should have to pay back who underwrites the policy, first of all. If there really is a debt owing, then it is not maritime life or manufacturer's life or Sun Life or whoever. It is who takes the risk of profit or loss in the insurance, who underwrites the policy. That's one problem. They misstate in the condition of benefits who is supposed to get paid back. But I said, secondly, there's a point about consent that the Ombudsman addressed back in 2003 that is entirely wrong. You guys said that people complained about Veterans Affairs Canada sharing information with CPPD without their consent, and then they said under the condition of benefits agreement and something else they gave consent. Well, consent has to be fully informed and freely given in order for it to be valid. Now, they put pressure, coercion, duress on us by saying, if you don't sign it, we're not going to pay you your insurance. So right there is what would the term in legal terms vitiates or voids the consent. You might have obtained consent, but it's not worth the paper it's written on. Now, the other thing is that it has to be fully informed. How can you say it's fully informed when you first of all misstate the insurer or the underwriter? The way they write it is you owe a debt to the company. That's the way they put it, the company. Well, no, that's not the way debt works. When I was working for Canada Revenue Agency, if I wanted to collect a debt and it was taxes, it was easy. I could send a set-off or a garnishee to whoever. But if I had to collect money from, say, property, if I had to seize and sell something, I had to follow the exact same procedure that a normal collector would take, and you had to register it with the sheriff. You have to get a judgment and you have to get the sheriff to seize and sell it, and then you only get a portion of the proceeds. That's the way debt collection is supposed to work. So if they are really owed the money, what they need to do is go to court, prove it to a judge. After they get it proven to a judge, it becomes a judgment debt and not just an allegation. After you get a court order about there really being debt owed, then you can proceed to collect it. What the government is doing, especially with estimation, is they're collecting a debt before it arises. You can't do that. You can't look at the future and say, you're going to owe money when you get it, so therefore blah, blah, blah. You just can't do it. Now, I'm about wore out, so I'll stop talking in a second, but there's another case that I was looking up, and I got to look up the exact case, but I found a picture of it, and it was about estimation, and it said, in consideration of the insurance payments being paid to you now, you agree to pay us when you get to Canada Pension Plan or whatever. You can't do that. That's not how insurance works. You're putting a future event that might never occur on the table. You can't make payments conditional. You buy insurance, insurance has to pay if the risk happens. If you buy insurance against disability and the disablement happens, they have to pay you. If you buy insurance and it's on your life, they have to pay your beneficiaries when the risk happens. That's the nature of insurance. But they're trying to eliminate the risk of having to pay. And people might say that that's normal, but it's not, because that voids the purpose of buying the insurance in the first place. If you buy insurance for peace of mind, which is another point I brought up, because I said the government of Canada is putting itself into very serious legal jeopardy. Instead of just having to pay back the money that it owes to people, because insurance is bought for peace of mind, and the government of Canada is doing this to disabled veterans that were hurt in the service to Canada, the risk of punitive damages, which is addressed as a quantum of what is really owed in compensatory damages, the risk of punitive damage is astronomical. Now, because I happen to have done a lot of research, what I said to the guy was, according to the Canadian Bar Association, these reimbursement agreements aren't worth a spit because, first of all, they have no consideration. Consideration in a contract is the money that changes hands. So in a contract, you have to have 3 items: an offer, acceptance, and consideration. The consideration, the condition of benefits agreement sounds official, sounds like you really would owe, but there was no consideration that was paid. The second point on that is that it's not part of the contract. It's after the contract. So the contract is, I pay you premiums, you pay me insurance if I become disabled. The condition of benefits agreement is after, outside the contract. So therefore, it's not part of the contract. Therefore, it's not enforceable. They get away with this because nobody takes them to task. They assume, and I think they're taking advantage of the soldiers' indoctrination. When they say jump, we say how high. They're taking advantage of our propensity to follow orders. That's despicable, because you shouldn't take advantage of people just because you've conditioned them. You can't afford to. In the military, you had to use muscle memory. You get orders so you don't have to think. But in cases where someone's asking you to get Canada Pension Plan Disability, and like I said in Ash's case, she had just finished a 24-month period. I said there's a 2-part definition in the Service Income Support Insurance Plan. For the first 24 months, it's own occupation, which means your own trade. Now, when she was qualified, because the letter that told her that she was going to have estimation of Canada Pension Plan said, congratulations, we're approving you to pay age 65 because you meet the totally disabled definition in the policy. That was the first paragraph, or the second paragraph. Now, the third paragraph said, now that you're going to be on it till 65, we're going to estimate Canada Pension Plan. Boom. They didn't even warn her or nothing. Normally, the estimation thing is done to force people to do it when they're reluctant. It's not done right away at 24 months. In Dion's case, for example, he's been ignoring their requests. And in my case, where they did it to me, I ignored the irrevocable consent form. So, because they said that I wasn't playing ball, Sun Life ignored the fact that I applied for Canada Pension Plan Disability, and they estimated my Canada Pension Plan Disability in March of 2014. Now, I got approved for Canada Pension Plan Disability in November of 2014, but they were estimating it 6 months prior. 8 months, is it? March to November. So, this is a shit show. All I can say is this is a shit show. Now, what I'm hoping to do eventually, when one of the things that I'm always talking about, because I happen to watch a lot of YouTube videos about the Ukraine war and stuff, the Russian invading Ukraine and stuff, and a pretty good analyst was talking about the boy who cried wolf problem. And he was talking about the Russians and the Ukrainians both saying they were going to blow up, or the other side was going to blow up a nuclear power plant. And the thing is that it didn't happen. So then people think you're lying or stretching the truth or something. Well, the thing is here is I've been talking about all of these issues for so long, and nothing's ever been done about to fix any of these things, that people think that I'm not telling the truth, or I'm mistaken, or I'm lying, or something, because I haven't had any success yet. But the thing is that there is an enormous government bias here, that they don't want any of this stuff to come out. Do you think they're going to want to fix something and have to admit that there was a mistake and have to pay tens of thousands of veterans billions of dollars? Do you think that they want to do that? Do you think that the insurance industry across Canada will want to pay a whole bunch of money back for the estimation of Canada Pension Plan Disability? Because it's not just veterans and public servants and RCMP members that this happens to. It happens to everybody across the board in Canada. The disabled are getting thrown under the bus. So, as an example of that, so that you know I'm not just crying wolf like I was just talking about, the Canada Pension Plan was running into money problems. So back in 1998, the government blamed the disabled, and they made it harder to get by increasing the vesting period from 2 out of 3 years, which was the old rule, into 4 out of 6 years. Now that's the 4 out of 6 year rule I was talking about. It used to be from 1966 up until 1998, it used to be 2 out of 3 years, which would have gave a 1 year period after you finish working to qualify for the Canada Pension Plan Disability. Now think about that for the Service Income Support Insurance Plan and other long-term disability that lasts for 2 years. That meant they couldn't get you to apply for the Canada Pension Plan because you only had 1 year after you got out to get it. So if you had a 24-month period under the Service Income Support Insurance Plan, 12 months in, you could apply for the Canada Pension Plan Disability, but you couldn't apply until after 24 months because CISA, well, they can't justify making you apply earlier, or they would have to say, we consider you totally disabled and therefore we're going to pay you to 65. So because they don't want to commit to that, they wouldn't be able to make you apply for the Canada Pension Plan within a year. So by changing it in 1998, they helped the insurance companies and the government because they allowed an extra year. But that is still a legal term. Like, you have to meet that. If you don't meet it, then how come in a public law, contract law is called private law. Public law is laws made by members of parliament and stuff like that. In a public law like that, you cannot say, I didn't know about it. Okay? You can't say that I didn't know that the government changed the rule back in 1998 and you are required to have 4 years before you end your service and then have 2 years after, so that gives you the window to apply. Now, what are we talking about here? We're talking about tens of thousands of dollars, and we're talking about people who sometimes can't look after their own best interests, okay? Because I'm going to get into this a bit later, and I plan to get into that with the Office of the Veterans Ombudsman. I mean, when you're down and out, you've lost your career, you had your property taken away because an Office of Employment is property. So you get medical release, and then you lose your property. You can take away a person's property in law, but you have to compensate them for it. Wells, Supreme Court of Canada, 1998. A St. John's mayor, who then became a provincial public servant, a public utilities commissioner, they didn't like him, so they legislated out his job. He sued and won. They said, the Supreme Court of Canada, you can take away someone's office of employment, but you can't take away without that property without compensating them for it. Now, when a person who's in the military, they don't have a contract of employment. They own an office of employment. So when their office of employment is taken away from them, they need to be compensated for it, just like the principle of the Andy Wells Supreme Court of Canada case and the Knight Supreme Court of Canada case, which the Andy Wells case referred to. Anyway, I think that's enough for tonight, but keep an eye on this because I think it should be a hot button topic, okay? When you're talking about, it might be a different thing if you could legally apply for these things. If someone could get the Canada Pension Plan Disability and somebody made them apply, it's a lot different than you can't get it and they make you apply. I hope you see my point on that, and have a good day.